Can I have your attention, please? We're going to go ahead and get started because the House session lasted overtime. We've lost an hour in our meeting time this afternoon, and we've got 4 or 5 bills that I really want to get out and go ahead and get those taken care of. We even have some discussion going over here right now on a couple of words. So I'm going to ask Representative Bubba Epps, what's your name? To lead us in prayer, please.
Thank you, Mr. Chairman. May we pray. Our Heavenly Father, we thank you for the abundance that you continue to bestow upon us. And our wish this hour that you grant us the wisdom and the courage to carry forth the actions that are in keeping with the quality of life and the concerns of the citizens of this great state. Please, we ask in your name. Amen.
Thanks, sir. Yeah, we have a quorum. I think the quorum's 5 because of the competition between us and other meetings. First bill we're going to hear today is House Bill 347 by Chairman Hembry. We're doing this bill, and this is the only bill we're going to do this way this year. He will present the bill. We'll have one speaker from the floor, Commissioner Hudgens. That make contact on this bill or give you some information, then we'll vote on it. All the other bills that are on the floor today have been vetted through committee or subcommittee. Everyone has had a chance to speak on these bills. I know there's some who said they didn't, and I question that because the first I heard about that was about 35 or 40 minutes ago. So if we're having a subcommittee meeting and you've got an interest in a bill, I would encourage you to be there. So I'm going to give it to 29. Bills, you're number 29. Yes. Chairman Hembry on House Bill 347.
Thank you, Mr. Chairman, and good afternoon. Thank you for your time. This measure is important. As many of you may know, there's a lot of time and effort that goes into becoming an insurance agent, a sub-agent, counselor, adjuster. There's an education process that you must complete as well as an examination process that must be completed. And House Bill 347 just simply says that provided that the commissioner shall not under any circumstance exempt himself or herself from any written examination requirements set forth by the code. It just says that if you're an acting commissioner for the department, that you cannot give yourself a license without going through the proper procedures as everyone else must do in taking the classroom time as well as taking the examinations. That's it.
Okay, I understand. Commissioner Hudgens, you want to speak on that, please, sir?
Thank you, Mr. Chairman. Am I on?
Yes, sir.
Thank you, Mr. Chairman, and members of the committee, and thank you, Representative Hembry, for taking this legislative idea and going to Legislative Council and turning it into a bill. An unfortunate situation happened, and I was offended personally. I think there's 137,000 licenses held in the state of Georgia, and all of these licenses, with very, 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 very few exceptions, the license holder has taken a test and have proved that they have the ability and the knowledge to conduct the business that license enables them to do. And it was unfortunate that our previous commissioner deemed himself an insurance agent and passed this. And I asked Representative Hembry, would he handle a piece of legislation that would make that impossible in years to come, and he graciously agreed, and I would be willing to answer any questions of anybody. I think that I have not heard any negative comment about this bill from anyone. In fact, it's all been positive comments, and I don't know exactly if we had enough time to get many co-sponsors, but I think you would not have any trouble getting co-sponsors on both sides of the aisle for this piece of legislation. So with that, I'll be glad to answer any questions.
Does anyone on the committee have a question? Don't see any lights on, Commissioner. Thank you, sir.
Thank you.
Well, I'm ready to entertain a motion then. Do pass in a second. All in favor say aye. Aye. All opposed, no. Unanimous. Thank you, sir. Okay, we'll look at House Bill 47 today by Representative Ramsey. And once again, this bill has been vetted in subcommittee, and the purpose of it today will be to take a vote. Representative Ramsey.
Thank you, Mr. Chairman and members of the committee. I guess today is kind of golden oldies today between the billboard and now this bill again. This is a bill that came through this committee last year. This is the identical version of the bill that this committee passed last year and the House passed last year. It got hung up on the other side of the Capitol, and we're optimistic that we're going to be able to get it all the way through to the governor's desk this year. But this is a bill that really gets at one of the most challenging issues facing state and federal policymakers today, and that's how to get more access to insurance for our nation's uninsured. Here in Georgia, we have 18% of our population that does not have health insurance. There's been a great deal of debate over the last 2 years, we all know, in Washington and here in Georgia on how to get at that problem. And there's a number of ways to skin the cat, and what you saw in Washington last year with the federal health care vote was one way, a way that I personally disagree with. But this is an alternative solution that I believe is right for Georgia, and I think it's going to put more power in the hands of our constituents to try to find a health insurance product that meets the need of their family from a coverages standpoint and a price standpoint. And there's a couple points before I describe the bill I think bear making. First, this bill only affects the individual insurance market in Georgia. Only about 5% of our state's population buys insurance in the individual market. It is a small but critical segment of the market because that's the marketplace that those uninsured have to go to buy a health insurance product. Those people that don't have insurance, they don't have access to a group plan. So when they do make the decision to get insurance, that's where they're going to have to go, is that individual market, and that's where this is focused. And the goal is pretty simple. We know intuitively, it's been true since the beginning of humankind, that the more power you put in the hands of a consumer, the better it is for that consumer. The more choice we give them in terms of prices, in terms of options, the more access we give them to a free market, the better it is for the consumer. It's been proven over and over and over again across societies and industries, and I believe it will work here. The goal is pretty simple, is to unlock those forces of the free market on behalf of our state citizens. And the mechanism is pretty simple. It's a pretty short bill. We've worked very closely last year with a variety of experts in the insurance industry to make sure we were the bill we drafted actually resulted in the impact that we intended. And that's to allow insurance companies that are licensed in the state of Georgia. It's important to remember we're not going to have companies that only operate in other states selling insurance policies to our citizens. This will allow licensed Georgia insurance companies to sell products that they also sell in other states. It's pretty simple. Right now, you have one type of policy you can buy with the 40-something mandates we have here in Georgia. This will potentially expand the universe of product options available to Georgia citizens by 50. If a citizen wants to buy a policy that has more coverage, they want to insure against more conditions and more types of risk, they'll have the option to do that. If one of the folks that are in that 18% of Georgians that are uninsured wants to shop for a policy that has less coverages, if they don't want to pay for a policy that includes chlamydia screenings or any of the other mandates that may not necessarily apply to a person that wants to buy a policy but can't necessarily afford it, then they'll have the option to do that. This is all about giving insurance companies the ability to offer more products and consumers the ability to go into the marketplace and find something that makes sense for their families. And that's what this is all about. And in fact, it was said during subcommittee, and I don't think the debate, there was a lot of folks that showed up to speak on the bill. and I can't remember who said it, but it was said, and I think it more succinctly than I could ever say sums up this issue. And they said, sometimes government has to step in and save us from ourselves. I refuse to believe that. My belief is that we should trust our constituents to go out into the healthcare marketplace and find a product that fits their needs from a price standpoint and a coverage standpoint. And that's exactly what we're intending to do here. That being said, we wanted to preserve all of the basic consumer protections that exist in Georgia law now for Georgians that have a grievance with their insurance company, that's how we've set this up. You have to go through the Georgia licensure process. If you have a disagreement with your company, you can still seek all of the redress afforded to you by the insurance commissioner grievance process that you can today. You can still have access to Georgia courts. You are, for all intents and purposes, buying a Georgia policy just with a greater range of coverage options because we're going to allow companies to sell products that they sell in other states. It's a simple concept. We believe we've struck a very good balance between unlocking these forces of the free market while also preserving our consumer protection that we have right now in Georgia for insurance buying consumers. So with that, that's the bill. We've been through it before. I'm happy to yield for any questions, and of course would very much appreciate the favorable consideration of the committee.
Okay. As I said earlier, this bill has been vetted in subcommittee, and the only ones who will be allowed to speak on or ask a question will be members of the committee. Do any members of the committee have any questions for Representative Ramsey? Okay. Seeing none, I'm waiting for a motion. Move to pass in a second. All in favor say aye. Aye. All opposed, like sign. No. Motion carried. Okay, the next on the agenda is House Bill 66, and if there has ever been a bill that has been vetted as much as this one, I would like to know it. I think Chairman Howard just kind of kicked over an ant's nest, and it all just kind of went out. So I'm gonna turn it over to Chairman Howard with his partner in crime there, and and Representative, it's all yours.
Thank you, Mr. Chairman. Thank you, Mr. Chairman, members of the committee. Yeah, we kicked over an anthill and opened up a real nest of, I think, killer bees on this thing. People have had a lot of interest in this bill. We've vetted it. We've tried to work with people in several different ways. I know there's still some that's not happy with maybe what exactly we've got here, but we feel like we've got something we need to move forward. We're dealing with the LC that should be on your desk at this time. Is LC 3711165S is the latest one I think we've come up with.
That's the one we have.
Okay. I think that was the latest one we've got here. What we're attempting to do here is help clarify the law that relates to the certificates of insurance that basically property and casualty companies, property and casualty insured issues to people that have insurance policies they need to take to various and sundry. Start out with contractors, subs needing to have certificates of insurance to take to their contractors to show that they had liability coverage or proper coverages that would allow them to get paid for subbing out work on jobs. It sort of developed into a few other things here. What we've done here, basically nothing in the bill is not new law. What's been in here has pretty much been the case to start with. And earlier in the year, the commissioner sent out a letter, what would you call that? Directive, indicating some of the things that could be done with certificates of insurance and how they would be handled. But basically what we've done in this is we've defined what certificates of insurance are. It states that certificates can only use to summarize coverage in an insurance policy that's in existence. An agent is not to go out here and falsify, put information in a certificate that is not already in a policy that has been issued and bound. Certificates are for informational purposes only, and they confer no rights on the certificate holder. And this is where we really got into the rat's nest of issues this year on that. It appears that many times people were taking this certificate and using that as a policy binder, thinking they had bound coverages, that they had policy rights for them to have cancellation notices and other information that is strictly for the policy holder or a lien holder or additional named insured, and they were assuming they had these rights as a certificate holder. We've made a couple of changes. I believe the last change we made in committee, you have that, it was on the line. The last sentence in D. Last sentence in D, I had it noted in here. 47. The certificate does not amend, extend, or alter coverage terms, exclusions, conditions afforded by the policies herein. However, the Commissioner of Insurance may approve a form filed under this code section that does not state that the form is provided for informational purposes only. In our last, or in our subcommittee hearing, the last subcommittee hearing, we understood that's what the folks wanted, and they seem to be in pretty much agreement with that. Since that time, we've had some other questions seem to arise, but we feel like we need to go ahead and move this bill out. And if there's anything that they want to do, it should be done maybe on the other side. We felt like we've had a pretty good hearing on this. So that's pretty much my presentation. If you got questions, I'll try to answer them individually. We've got Google here to help me with it.
Okay. Does anyone on the committee have a question? Goodness. Well, I'm waiting for a motion. Recommend do pass now. Second. All in favor say aye. Aye. Likewise say no. Okay. It carried. Thank you, sir.
What's the matter, Mike?
Yeah, he made motion. He made the motion and voted no.
Thank you, Mike. Thank you, Mr. Chairman.
Thank you. You can return the favor. His bill's next. House Bill 156. Representative Chokas. What is that? Okay. Representative Chokas, you have House Bill 156.
Thank you, Mr. Chairman and members of the committee, and I want to apologize for that snafu I made just a moment ago, but 7:30 came awfully early this morning. Today I bring to you House Bill 156. It basically adds the state highway employee to the list of the people that are currently would be able to receive permanent or partial disability under a state insurance plan. I think it was absent. State Highways and Ports was absent unintentionally, and in lieu of what's recent events, that it would only be appropriate for us to add state highway employees to law enforcement officer, firefighter, emergency medical technician, emergency management rescue service, prison guards that would be eligible for this coverage. And at this time, I'd entertain any questions that y'all may have.
Does anyone on the committee have a question? 28. Identify yourself so that.
Thank you, Mr. Chairman. Representative Carolyn Hughley from Columbus. As you go through this legislation, there are particular dollar amounts. Since we're updating this section, did you give any thought to these dollar amounts that are included in here? For example, on line 14.
14, the dollar amounts were $35,000. We did not change those dollar amounts.
That's what I'm asking. So you all, that was not part of y'all's discussion?
No, ma'am. No, ma'am.
Correct me if I'm wrong, but only thing you did on this bill was just add state highway employee.
That is correct.
Okay. Are there any other questions? Move to pass. Here a second.
Second.
All in favor say aye. All opposed, like sign. House Bill 156 passed and will be sent over to the Senate.
Thank you, Mr. Chairman and members of the committee.
House Bill 167.
Thank you, Mr. Chairman and members of the committee. It's my pleasure to bring to you House Bill 167, aptly named the Insurance Delivery Enhancement Act of 2011. It's got several different sections on it, and I'll just go right through it if you don't mind, Mr. Chairman. Sections 1, 2, and 3 deal with a provision under the trade association clauses, so small business groups that can pull together and offer affordable health care coverage to their employees. And basically what we're doing is we're loosening some of the restrictions on these associations and lowering the standards from 25 members down to 10. Additionally, for the first time, we're also going to implement in Section 3 1099 employees and their spouses as members, or just like we would on W-2s. And previously they have been excluded from that. The rest of the bill deals with the prompt pay statutes that we've debated, and I know that the chairman said that there was not many bills that were vetted much more than one of our earlier ones, but this one's been vetted pretty good and worked over pretty good for several years now. And basically what we're looking at here under the prompt pay statutes is bringing a level of fairness and bringing the same guidelines for third-party administrators as major insurance carriers. There's a lot of discussion dealing with ERISA standards and preemption, and this bill really does not affect ERISA. We have legal counsel that has given us numerous opinions time and time again that this does not violate or preempt ERISA. And I have that if anyone would like to see it. I've got copies of it for the members. But basically what the bill is going to do is current prompt pay statute says that they have 15 days to file to pay their claims or tell the provider why they're not paying it. This bill will actually give them the 15 days on electronic claims and 30 days on paper claims. Obviously that's the exception to the rule. Most everyone is going to electronic. However, we'll give them the extra 15 days to deal with a paper claim. Obviously it's a little bit harder to process. We are lowering the penalties from 18% to 12%. We're also putting into law that the penalties will not apply until they become less than 95% compliant. And other than that, I mean, we can go by line if you'd wish, Mr. Chairman, but this was vetted in subcommittee. It passed out overwhelmingly, I believe, an 8-to-1 vote, passed by supermajorities both in the House and Senate last year, and unfortunately was vetoed by the governor. And I'll be happy to take questions, Mr. Chairman.
Okay. Anyone on the committee have a question? 24. Identify yourself.
Yes, this is Darlene Taylor, and thank you for presenting the bill. It does have several good parts in it, but I do have a concern with the ERISA preemption. We've discussed it briefly. I have been in touch with and been contacted by the Self-Insurance Institute, and they do feel like it is an ERISA preemption, and they actually quoted the Schollendinger and United Healthcare, and in that particular case it had to do with the states mandating different rules. ERISA specifically does have mandatory rules for paying, and I think the difference is 30 days is what it says under ERISA to pay. Their indication was that it does preempt ERISA, and it would probably, I know you've got legal counsel that says it was, but most standings have found that ERISA has held, and there was also another case in the 8th Circuit, the same thing happened, where the prompt payments were involved, and it does interfere with the federal mandates, and I would hate to see us get involved in a long, drawn-out court case. Part of the bill is great, and I don't know what the numbers are, the percentages where they're not being paid promptly, but again, I don't want to see us get into something we then have to go and defend. Thank you.
And I appreciate those comments. And just briefly, the Schudinger, I believe that's how you pronounce that, the Schudinger case was brought to my attention over the last couple of days. And this was based off of Missouri law that I haven't seen. I don't know the language, if it even matches this language. We narrowly crafted this bill through legal counsel. I'm not an attorney myself, but we crafted it intentionally not to affect ERISA. That was in another federal circuit, was out of Texas, I believe. And I've learned a lot about federal circuit court cases and how one can't bind another circuit. And quite honestly, I don't know how that impacts this piece of legislation versus some other piece of legislation that we're not familiar with the language of.
Any other questions? No, 27's not working. 24. Whoops. Okay, up under number 12.
Representative Alex Atwood, just one quick question, Mr. Chairman. I want to be sure I understand your testimony. This doesn't even kick in until they are over 5% in being behind in their payments. Is that correct?
That's correct.
Is that what I understood?
In any given quarter,
Okay.
and that's how they track their claims, is on a quarterly basis.
Thank you.
24.
I want to make sure that I understand this also. It is requiring the Commissioner's Office now to have to handle and deal with quarterly reports from carriers. And again, it's more cumbersome bureaucracy at the Commissioner's Office to track and file these reports monthly by carriers and TPAs. Is that correct?
Well, most of the TPAs, and just so we're straight on this, most of the TPAs are major insurance companies. They're already filing these claims, and they're already being regulated by our insurance commissioner. We heard the insurance commissioner in subcommittee testify on behalf of this legislation, and he felt like his staff was more than adequate to handle this.
Okay, any other questions? Okay, I think it may be the proper time.
Mr. Chairman, at this time I do be passed.
Do I hear a second? All in favor, say aye. Aye. All opposed, like sign. Okay, got 2 noes.
Thank you, Mr. Chairman and members of the committee.
Thank you. Okay, we get finished with these. We'll break up for 3 o'clock. Yeah, I'm hungry. Okay, House Bill 189, covered dental services. Chairman Joe Wilkerson. And I think Representative Maxwell's going to join him down there.
The only thing missing is Colonel Bill Hitchens, and then you couldn't tell the 3 of us apart. Thank you, Mr. Chairman, fellow members of the committee. Let me thank Chairman Maxwell. As you know, I was in meetings last week, and he presented this bill to subcommittee, and thank you very, very much. It's very straightforward. It's, as you know, we can avoid having to have legislation on for that, but 26 states have already done this, 16 have passed, 10 are in the process. Bottom line is this, that what we're asking for, that no contract or agreement between a dental insurer network and a dentist should require the dentist to accept an amount for dental care services that are not covered, dental services under a dental benefit plan. And frankly, you can transfer dentists and small businessmen, because that's exactly what they are. What has happened is an insurance company will say to a dentist, we're going to cover these procedures for your patients, but you in return you have to agree to charge X amount. Let's say we get to a situation where you get 2 cleanings a year, which is pretty much it. Let's say the dentist says, it looks like a lot of coffee or something. I would suggest, or it could be you come into the dentist and say, I would like a 3rd cleaning. He agrees. It's not covered. Well, the dentist is required to submit a claim, even though it won't be paid, to the insurance company. That's the process. What's happening, though, is not covered procedures, which are mainly cosmetic, veneers, whitening, and so forth. Non-covered services, the insurance companies are saying, oh, you have to send these to us as well. And just my sense of fair play, my sense as a small businessman, I don't think they should be required to have to do that for a non-covered service.
Are you referring to electives when you talk about non-covered
Yes.
services?
Yes,
you know, like crowns and all like that, that's covered.
Yes, sir.
But for whitenings and whatever, electives would not be covered.
Oh, yeah, that's right. Thanks, Howard. That they are required, if for a non-covered service, they're saying, well, you have to give a discount. Well, I have a problem with that. I mean, I as a small businessman, should be able to set my price, and it's I think it interferes with the dentist-patient relationship. I can negotiate with my dentist on non-covered services. I have on whitening. I was able to negotiate it down to 50% of the cost, and I just don't think it's appropriate for some other company or big business to tell a guy, you or a gal, that you have to give this discount. It's just fair play, free enterprise, and that's where I've been coming from on it. That's what it does.
Are y'all finished with your
Well,
testimony?
bottom line is, again, it'd be nice if we didn't have to do it. What'd be great is if the insurers would cover everything. You know, dental insurance policies only cover $2,000. Why not just cover everything and let the dentist and the patient decide? That would be the answer, but obviously they're not interested in that. So we see no other ways but to ask for this, as have 26 other states.
Okay. Y'all ready for questions now?
Yes, sir.
Oh, you're ready for a motion. Well, before we do the motion, are there any other? Does anyone on the committee have a question? 19. Recognize yourself and ask your question.
Thank you, Mr. Chairman. I'm Mike Chokus, District 134, and my question is, on line 37, it says, no contract between a dental insurer and a dentist shall require a dentist to accept an amount set by the dental insurer as payment for dental care service that is not covered under dental services, under the covered person's dental benefit plan. Does that mean that the dentist, if he wants to voluntarily enter into an agreement with the insurance provider, does that prevent a dentist from doing that? Is that language? So if the dentist, let's say, wants to participate, or does that mean that the dentist cannot participate?
I think it just means they shall not require a dentist. It's not going to say the dentist can't do it of his own free will, but if they come in there and they can't have a contract before the dentist that says you're going to be required to accept our payments for non-covered services, and along with our payments for covered services, he can do whatever he wants to.
So he could go ahead and voluntarily participate in a plan that the insurance company had.
Yeah, it just can't be required.
Can't be required. Okay, thank you.
I would read it. I'm sorry.
Any other questions from someone on the committee? Okay, Representative Neal. Have a motion to do pass. I have a second. All in favor, say aye. Aye. All opposed, like sign. Motion carried.
Thank you, Mr. Chairman.
Thank you. Okay, we have one piece of legislation left. Oh, and by the way, folks, this is on our second full committee meeting, so this is the way it's going to be. We're going to have our subcommittees do all the vetting, or as much as we can in those, and when we come before the full committee, there'll be no public hearings. There'll be a chance for the committee members to ask questions, and then we'll vote and go home. So I'm going to turn it over to Representative J. Neal on House Bill 248.
Thank you, Mr. Chairman. I think I'm sitting between you and lunch, if I understood you correctly. House Bill 248 is a pretty simple bill. There are presently 3 that I'm aware of healthcare sharing networks that are operating in the country, and as far as I'm aware, all of them have individuals who live in Georgia that are part of them. And let me just share with you what a healthcare sharing network is quickly. And I'll tell you first of all that my wife and I were a member of one back in the mid-'80s. Very pleased with this network that we were a part of, and just to share with you briefly what it is. It is defined on beginning on line 16 as a faith-based nonprofit organization, tax exempt under the Internal Revenue Code, which does several things. It limits its participants to those who are of a similar faith. It acts as a facilitator among participants who have financial or medical needs and matches those participants with other participants that have the ability to assist. It provides for financial or medical needs of a participant through contributions from one participant to another. Provides amounts that participants may contribute with no assumption of risk, and that's an important part, no assumption of risk or promise to pay among the participants, and no assumption of risk or promise to pay by the healthcare sharing ministry. It provides a written monthly statement to all participants that lists the total dollar of qualified needs submitted to the ministry that month, as well as the actual amount that each individual is to contribute and the person that it is to be sent to. It provides a written disclaimer on all applications and guideline materials that says this: notice, the organization facilitating the sharing of medical expenses is not an insurance company, and neither its guidelines nor plan of operation is an insurance policy. Whether anyone chooses to assist you with your medical bills will be totally voluntary, because no other participant will be compelled by law to contribute toward your medical bills. As such, participation in the organization or a subscription to any of its documents should never be considered to be insurance. Regardless of whether you receive any payment for medical expenses or whether this organization continues to operate, you're always personally responsible for the payment of your medical bills. And then it makes it very clear that these ministries are health care sharing arrangements with participants. They're not insurance companies, health maintenance organizations, or health benefit plans of any class, kind, or character, and therefore not subject to any of the laws respecting insurance companies, HMOs, or health benefit plans of any kind, class, or character. And I would say to you that this is a great example of individuals taking personal responsibility for their health care and becoming a part of an organization where members of that organization assist one another by paying for their medical needs as they arrive. When my youngest daughter was born back in the mid-1980s, we received checks from a number of people all over the country to pay for those medical costs. It's a great opportunity for individuals to share one another, which is the Christian and brotherly thing to do. And this bill simply identifies what they are, makes sure everybody understands it's not an insurance company and not subject to the rules and regulations as such.
One quick response, and I think this was answered during subcommittee. The insurance commissioner's office is on board with this.
Insurance commissioner's office is completely on board with this. There are 8 other states that have already enacted similar legislation, and hopefully we'll see more of that happening across the country. And by the way, Obamacare, with the requirement to have health coverage, carved out an exemption for people who are participating in such networks and deems them as being covered.
Okay. Got a question, number 17. Mr. Lucas, which one's your number?
17 for me.
Oh, you're 17, okay.
Mr. Chairman, you just already basically said the thing I was going to in subcommittee, but the fact of the matter is the insurance commissioner has indeed approved or endorsed.
Yes.
Thank you, because that was in subcommittee and I thought that was powerful.
Yes.
Okay, Mr. Lewis, we have 2 ahead of you. So, number 21.
Howard Maxwell. Mr. Chairman, I'm sorry I missed the subcommittee meeting. By the time I got there yesterday, I had another meeting. Y'all were through. I was running to get there. But if we had this before, I guess my question is, if you were able to do this in a previous life before you came down here, well, why are we having to pass legislation? Is there something changed that's caused us to have this?
We're not establishing anything. This is something that's already existing. What is happening, there are some insurance commissioners that begin to look at this and say this is an insurance and subject to the rules, the laws and regulations of insurance companies, which creates, as you know, a whole new bureaucracy another level for them. And all we're doing is defining it in statute and saying we recognize that this health sharing ministry is not an insurance. We're not enabling anything. We're not setting anything up. We're just defining it in statute and clearly stating that it's not an insurance or HMO.
In the past, you could do this without having any type of...
Oh, you can still do it. You can do it now.
You can do it now.
Yeah, we're not addressing a problem. We're addressing a potential problem. We're
Okay.
preempting the potential that an insurance... And Commissioner Hutchins is 100% on board with these, but the next insurance commissioner might not be. And we're just wanting to make sure that everybody understands clearly that these are not insurance companies.
25.
Yes, thank you, Mr. Chairman. Representative Neal, just a quick question. It says that it's faith-based and it was limited to people who are of similar faith. Would that preclude another group that maybe not faith-based that want to set up an organization similar to this, or how would that function?
This does specifically identify that it's participants of similar faith. How do you want to define similar faith? If you want to talk about people that their faith is, I have faith to believe that there's no God, and then I'm okay with that. I guess
Okay.
that would be a similar faith.
All right.
But, so it's not restricted.
So it's up to the organization to define that.
That's correct.
All right, thanks.
The three that I'm aware of are purely Christian.
Yeah, I would
organizations.
imagine so. Yes, sir.
Representative Lucas.
Representative, are you telling me you can do it right now and don't need this?
Absolutely. 1982 was when the first one was established. There were two others established in the early 90s. There are about 110,000 individuals that are presently covered in all 50 states.
Well, there's got to be something. What are you running from? I mean, if it's private, to me it's private, and you explained that people all across the country sent you donations. What is coming that we don't see?
I don't know that it's a case of what's coming. I think that there's the fear of the heavy-handed bureaucracy if they begin to identify this as an insurance and start requiring the reserves and all the different things that come along with insurance could create a problem for an organization like this. And all we're doing is simply defining organizations that have been in existence for 29 years and saying this is what they are and this is what they're doing, and it's clearly not an insurance. And one of the notices on any application or anything about it talks about being a sharing of medical expenses, not an insurance company. There's no guarantee that you'll ever receive any money from them. It is a partnership and a network to where when you have a need, you submit that need to the main office. They tally up all the needs that came in from all the members that month. They divide them by the number of members to get the amount that each member has to pay to cover that entire need. And then they send out a newsletter. And every month we would get a newsletter with the name and address of an individual that we needed to send our check to and how much that check needed to be. And we'd write out our check and send it to them. And one of the great things about this is not only did we receive the money to pay the medical expenses, but we got cards with checks in them, not just checks in an envelope. With a message from somebody, congratulations on the arrival of your baby, praying for you and your family. And when you have that kind of a personal ability to share with one another with medical expenses, I think we need to do everything we can to make sure that it's clearly identified and protected.
The reason I ask, I mean, I do it all the time. There are folks who have cancer, young kids who have cancer. We have car shows to raise the money and send to them. That's basically doing the same thing, isn't it?
Well, but I think it's the same kind of heart or the same kind of attitude that causes you to want to be a part of something like this versus and what you're talking about doing. The difference in this is ultimately every month I get that one person that I'm assigned to send that check to that individual for that need. And when I submit that need, I've got a checklist of the people who are supposed to send me a check, and I check those names off as they come in to make sure that the needs are being met. And if I have 3 or 4 checks that don't come to me and I'm 3 or 4 short, I submit that back to the main office. They reach out to those individuals to see what happened, and if they don't have, if they've lost their job and they don't have the money, they can't send it. Then when the next newsletter goes out, there'll be 3 additional people that will be assigned to send me. It may be the next month before I get my check, but ultimately I'll get it. Is there a guarantee? No. It's very clear. It's your personal responsibility. But I can tell you from experience, I can tell you from 30 years of this working across the country, this is a great opportunity to provide personal responsibility in your health coverage.
Last question. If we pass this, does that mean then you're able to write it off your taxes if you send the money out?
This will change in no way any of those type of things, and I don't know the answer to that. I don't think you can write it off on your taxes. I don't know the answer to that. But this bill won't change that in any way. All this does is says that we recognize that these companies are operating out there, and we recognize that they're not insurance companies.
Okay, I don't see any other questions. Do I hear a motion? Recommend do pass. I hear a second. Second. All in favor say aye. Aye. All opposed, like sign. Motion carried. Thank you, sir. Y'all have a great weekend. Drive careful, and we'll see you Monday. Yeah.